Veuillez vous asseoir.
Please be seated. The sitting is open. For reasons duly made known to me, Judge Abraham is unable to sit with us today. The court meets this morning to hear the first round of oral argument of the Republic of Azerbaijan on the preliminary objections raised by the respondent in the case concerning application of the International Convention on the Elimination of All Forms of Racial Discrimination, Azerbaijan versus Armenia. I shall now give the floor to the agent of Azerbaijan, His Excellency Mr. Elnur Mamedov. You have the floor, Excellency.
Merci bien, Monsieur le Président.
Thank you, President.
Madam Vice President, members of the Court, it is an honor to appear before you again and to do so on behalf of my country, the Republic of Azerbaijan. Last week, Azerbaijan explained that Armenia's third application falls outside your jurisdiction, either wholly because Armenia rushed to file its application before giving negotiations a chance, or in large part because it misuses the cert in an attempt to bring before the court a kaleidoscope of IHL and other allegations arising out of armed conflict. As is clear on its face, and as Azerbaijan will explain this week, Azerbaijan's third application is completely different. Yesterday, Armenia's council accused Azerbaijan of having reformulated its third complaint in response to Armenia's preliminary objections. So let me set the record straight now. I will start by reiterating what exactly is Azerbaijan's third complaint, as advanced in its memorial and accompanying submission, before Armenia submitted any preliminary objections. Azerbaijan's third complaint goes to the very heart of the convention. It centers upon a 30-year campaign of ethnic cleansing and related cultural erasure by Armenia of the Azerbaijani population and culture in the formerly occupied territories, following Armenia's illegal invasion in 1991. In open defiance of multiple United Nations Security Council resolutions, Armenia implemented a systemic campaign to drive the Azerbaijani population from their ancestral homes, install a mono-ethnic Armenian population in its place, and deny Azerbaijanis any ability to return. The facts and evidence that Azerbaijan has submitted with respect to the targeted deployment of landmines, booby traps, and environmental destruction form just part of that systematic, racially motivated campaign. Yesterday, Armenia's agent vigorously denied that Armenia had ever, and I quote, endorsed racist ideologies, illegally occupied Azerbaijan's territory, or controlled the authorities in Nagorno-Karabakh, unquote. This is sophistry on the part of Armenia. It ignores the overwhelming response of the international community to Armenia's invasion and occupation of Azerbaijan, which rejected Armenia's conveniently created self-determination narrative. Not a single state in the world bought into this fairy tale. The United Nations Security Council issued multiple resolutions demanding immediate, complete, and unconditional withdrawal of the occupying Armenian forces from the sovereign territories of Azerbaijan. It also ignores the jurisprudence of the European Court of Human Rights, confirming Armenia's effective control over those territories, and the trilateral statement of 10 November 2020, by which Armenia committed to withdraw its troops from and thereby relinquish its control over those sovereign territories of Azerbaijan. And it ignores the fact that Armenia's culpable conduct was driven by an openly racist and nationalist ideology known as Tekachron, or race religion in Armenian. Last week, the agent of Armenia dismissed Tekachron as, and I quote, an early 20th century national ideology which has nothing to do with the mainstream political realities in Armenia today, unquote. But it was striking that Armenia did not dispute the fact that Tekachron was and is a racist ideology, or the fact that Ter-Petrosian had everything to do with Armenia's political realities during its campaign in the formerly occupied territories throughout the years of occupation. Throughout most of its occupation, Armenia was ruled by the Republican Party of Armenia, or the RPA. The RPA was and remains a staunch follower of Ter-Petrosian ideology, idolizes its founder, Karagin, and even today, it proudly proclaims on its website that it is, and I quote, the ideological and political successor of Nijde Ter-Petrosian Profesios and National United Party, unquote, whose, and I quote, ideological basis is Karagin Nijde's teaching, unquote. I invite the court to reflect on some of Nijde's teachings, quotations from which appear on the screen. Central to them is a notion of a superior Armenian Aryan race, the consequential racial inferiority of Azerbaijanis, called in his teachings Turks, and the unification of all ethnic Armenians within a single mono-ethnic state extending into Azerbaijan's and neighboring states' sovereign territories. The teachings call Azerbaijanis those, and I quote, who for centuries had more dark traits in themselves than human, unquote. For more detailed extracts from Nijde's teachings, I refer you to tab 2 of the judge's folder. Karagin Nijde remains a national hero in Armenia. On the slide, you see 2 statues of him in Armenia erected in 2016, one of which was unveiled by then the president of Armenia. Nijde is also venerated by fascist groups in Armenia. Here you can see a recent parade by one such group on the main square in Yerevan, which ended in a collective Nazi salute to his statue. I pause to note that Armenia failed to take any measures to prevent this openly racist event, despite the court's provisional measures order dated 7th December 2021. For a state supposedly committed to the eradication of racial discrimination, I wonder why Armenia allows such parades to take place in its capital in broad daylight today. Mr. President, members of the court, last week, when addressing Azerbaijan's third claim, the agent for Armenia also asserted that Azerbaijan is unable to present any hate speech or video evidence of racist atrocities. That again is patently false. My next slide shows just a few examples of the hate speech that drove Armenia's culpable conduct in the formerly occupied territories, taken from Azerbaijan's application and memorial. They include statements about the ethnic incompatibility of Armenians and Azerbaijanis, describing even the idea of coexistence as a tragedy, and the labeling of Azerbaijanis as being at a different level of civilization. The level of Armenian hate speech against Azerbaijanis was such that in 2021, as you can see on the screen, Twitter identified over 30 accounts, all associated with the Armenian government. These accounts were either spreading hate speech against Azerbaijanis or were fake accounts pretending to broadcast Azerbaijani hate speech against Armenians. Armenia seems to have been so concerned with hate speech against Armenians that it took great efforts to create more. And as far as video evidence is concerned, contrary to the assertion made by the agent for Armenia, Azerbaijan's application alone was accompanied by no less than 17 videos showing appalling racist atrocities committed against Azerbaijanis. Azerbaijan's third case against Armenia manifestly falls within the substantive scope of the convention. Having illegally invaded and occupied Azerbaijan's territory, Armenia proceeded to execute over the following decades the pervasive racist agenda that is the subject of Azerbaijan's complaint. Armenia's campaign was multifaceted, comprising an array of conduct, including the laying of booby traps and landmines, and a devastating assault on the natural environment and resources of the formerly occupied territories, all of which targeted the local Azerbaijani population or the prevention of their return. This last point is critical. Yesterday, Armenia's council made the extraordinary and extremely misleading submission that Azerbaijanis had no intention of returning to those territories, while Armenia was busy laying its landmines and booby traps, looting resources, and reaping environmental devastation. I could hardly believe my ears, and I had to review the transcript to be sure. No doubt, Armenia's agent knows that it was widely expected and widely demanded that Armenia must withdraw from the occupied territories and allow the many hundreds of thousands of displaced Azerbaijanis to return to their homes as part of any peaceful settlement of the conflict. Azerbaijan consistently demanded the return of its displaced persons. Its demand was recognized by international bodies. The Security Council consistently recognized that any resolution of the conflict would entail such return. It was always a critical component of any negotiations. To be sure, it was always understood that key principles of any agreed settlement would include: 1, the return of the territory surrounding Karabakh to Azerbaijani control, and 2, the right of Azerbaijani displaced persons to return to their former places of residence. It is therefore puzzling that Armenia did not expect Azerbaijanis to return to the areas Armenia intentionally pillaged. The map on the slide depicts the formerly occupied territories of Azerbaijan. You can see the purple lines show the former Nagorno-Karabakh Autonomous Oblast of the Azerbaijani SSR, which had been majority populated by ethnic Armenians prior to the invasion. The yellow lines depict the additional 7 occupied districts whose population was 99% Azerbaijani before the invasion. As Professor Boisson de Chazourne will explain, and the court can see on the map, the vast majority of the environmental destruction by Armenia was deliberately targeted at those 7 districts. Again, these were districts to which everyone, including Armenia itself, was aware that the majority Azerbaijani population was expected to return if a settlement were to be reached. This explains the pattern of environmental destruction in those specific areas where Armenians did not leave and Azerbaijanis were expected to return. Armenia was determined to frustrate the return of Azerbaijanis to their homes and thereby to preserve the racial purity of its occupied territories. Armenians claimed that it could not anticipate the return of displaced persons or that Azerbaijan gave it up is simply nonsensical. Even today, the return of Azerbaijanis previously displaced from the formerly occupied territories remains inhibited by Armenia's misconduct, as Azerbaijan works to reinstate critical infrastructure, identify and remove landmines and booby traps, and restore the natural environment. Hundreds of Azerbaijanis, mostly civilians, have lost their lives or suffered horrific life-changing injuries due to the landmines and booby traps which Armenia placed in order to prevent their return. Armenians even continue to celebrate such tragedies. Some recent Armenian social media posts are on my next slide. Not only does Armenia refuse to provide Azerbaijan with detailed maps of its landmines, but it has failed to abide by its obligation to prevent and punish such blatant hate speech. Armenia's time would have been better spent combating online racism by its own nationals than browsing the web for fake Azerbaijani army badges. Mr. President, members of the court, there is one additional aspect of Armenia's invasion and 30-year occupation of Azerbaijan's territories that warrants attention. Armenia's misconduct included many infamous examples of grave breaches of international humanitarian law and other international human rights norms by Armenia's armed forces. Armenia has resolutely refused to investigate or prosecute them. Importantly, though, and in contrast to Armenia's approach, Azerbaijan does not claim individual breaches of cert with respect to that misconduct. Rather, Azerbaijan treats these acts as elements composing Armenia's wholesale racist campaign. Similarly, Azerbaijan does not claim that the placement of landmines and environmental destruction constitute individual breaches of cert, but rather as integral components of Armenia's campaign. Mr. President, members of the court, Armenia presents 3 jurisdictional objections to Azerbaijan's cert complaint, each of which is designed to exclude aspects of its racist campaign from analysis by the court at the merit stage. First, it makes a ratione temporis objection with respect to claims concerning events prior to 15 September 1996, when Azerbaijan became a cert party. Second, it submits a ratione materiae objection with respect to the targeted placement of landmines and booby traps. And third, it submits another ratione materiae objection with respect to Azerbaijan's claims concerning deliberate environmental harm. Azerbaijan is confident that you will dismiss each of Armenia's 3 objections to jurisdiction at this stage, and thereby allow Azerbaijan's cert complaint to proceed to the merits. Armenia also submits a separate objection to admissibility, arising out of what it calls, and I quote, Azerbaijan's 3-decade delay in bringing its claims, unquote. If accepted, this would prevent the court from assessing Azerbaijan's cert complaint at all. Armenia tries to use its 30 years of unlawful occupation, during which it prevented access by Azerbaijan, by the UN agencies and other international organizations, as a means of precluding Azerbaijan from complaining about Armenia's racist occupation campaign following liberation of its territories. Armenia cannot benefit from its unlawful conduct. In this context, it is imperative to note that Azerbaijan has brought its application based on evidence which it has discovered and continues to discover following the liberation of the territories in 2020. Thus, for example, following the liberation of our territories, we have discovered ruined cities, destroyed cultural monuments, and a devastated environment. And in the last few weeks, Azerbaijan has continued to find new evidence of the deployment of booby traps to inhibit the return of ethnic Azerbaijanis to their homes. In tabs 7 and 10 of your judges folder, you will find references to the multitude of evidence Azerbaijan presented to the court and keeps uncovering subsequent to the liberation of its territories in late 2020. Accordingly, Azerbaijan's application arises out of a timely and orthodox invocation of the ICJ's jurisdiction under Article 22 of the Convention. If Armenia got its way, Azerbaijan would have been compelled to bring a cert claim before the liberation of its territories, and without access to much of the evidence on which it now relies. This is plainly disingenuous. Professor Talman will address you further on Armenia's flawed admissibility complaint. Ironically, if any party delayed its cert complaint, it was Armenia itself. Last week, Armenia's agent described Armenia's complaint as, and I quote, the culmination of decades of racial discrimination against ethnic Armenians, unquote. And yet, Armenia never communicated any cert complaint to Azerbaijan over that many decades period. Instead, as Armenia itself admits in its application, it waited until 11th November 2020, more than 24 years after Azerbaijan's accession to the cert, but just one day after the end of the Second Karabakh War, just one day, before notifying Azerbaijan of its cert complaint. Clearly, this timing was no coincidence. One can only wonder why Armenia had waited until it lost control of the territories of Azerbaijan as a result of the Second Karabakh War before rushing to the court with its third application against Azerbaijan. Mr. President, members of the court, Azerbaijan's oral submission this morning will proceed as follows. Mr. Steven Fieda will provide an overview of Azerbaijan's third complaint. Professor Van Loo will explain why Armenia's preliminary objection, ratione temporis, should be rejected. Professor Stefan Talman will then explain why Armenia's admissibility objection fails. Mr. Sam Wordsworth and Mr. Sean Oki will each rebut the legal and factual aspects of Armenia's preliminary objections with respect to landmines and booby traps. And finally, Professor Laurence Bosson de Chazourne will refute Armenia's objection with respect to the environmental damage it caused during its occupation of Azerbaijan's sovereign territories. Mr. President, members of the court, I thank you for your attention, and I kindly ask that you invite Mr. Steven Fieda to the podium, who will provide an overview of Azerbaijan's third complaint.
I thank the agent of Azerbaijan for his statement. I now invite Mr. Steven Fieda to take the floor. You have the floor, sir.
Mr. President, members of the court, it's a privilege to appear before you and to present this introductory overview of Azerbaijan's third case. I have a number of overarching points to make, bearing in mind last week's hearing in this court, before my colleagues address you on the specific issues before you this week. The two cases before you, Armenia versus Azerbaijan and Azerbaijan versus Armenia, arise, of course, out of broadly the same factual background. But Azerbaijan's case has been carefully framed and presented in a manner different from that presented by Armenia, and the difference bears directly on the question of preliminary objections. As the court will recall, there are three main phases in the history relevant to this case. The first phase, Armenia's territorial claims over Azerbaijan, led to armed hostilities in 1991. By the time a ceasefire was established in 1994, Armenia was illegally in occupation of the Karabakh region and 7 surrounding districts of Azerbaijan. For brevity, I shall refer to the occupied area as the Karabakh region. The UN Security Council called for the complete, immediate and unconditional withdrawal of the Armenian occupying forces. The 1994 ceasefire ended the First Karabakh War and thus the first phase. However, Azerbaijan was unable to liberate its occupied territories within which the so-called illegally installed regime controlled by Armenia was established. Phase 2 comprises the illegal Armenian occupation of Karabakh, which continued for almost 30 years. The occupying Armenian forces did not withdraw until the 44-day Second Karabakh War, which lasted from 27 September to 10 November 2020. Following mediation, a ceasefire agreement known as the Trilateral Statement was signed by Armenia, Azerbaijan and Russia. But even then, Armenia continued to deploy military units in part of the Karabakh region, posing a serious threat to regional peace and stability. It was only through the counter-terror operation on 19th and 20th September 2023, which began Phase 3, that Azerbaijan was able fully to restore its sovereignty and control over the formerly occupied areas. You heard much last week about atrocities allegedly carried out by Azerbaijanis. Many people watching these proceedings in Azerbaijan and elsewhere will feel anger at this one-sided account. They will recall not only the violent expulsion by Armenia of over 1 million Azerbaijanis from their homes, and episodes such as the Kajali genocide, which was recognized by 17 states as such, and the razing to the ground of the city of Agdam, later described as the Hiroshima of the Caucasus. Their recollection will extend also to the whole range of Armenia's campaign of ethnic cleansing, from individual acts of egregious cruelty to the clinical, systematic use of landmines in particular locations to prevent the return of displaced Azerbaijanis to their homes. Many people watching these proceedings will be frustrated that Azerbaijan's counsel are not setting the record straight on all of this. But now is not the time for that work. The discussion about individual atrocities last week arose because Azerbaijan was illustrating its basic point that not every alleged action by an Azerbaijani against an Armenian could be assumed to be motivated by racial animosity. The mere fact of deploying a landmine or a cluster bomb does not always, in all circumstances, violate the CERD. Something more is required, such as evidence that particular racial or ethnic groups have been targeted. In much of its case, Armenia has not shown that something more. It simply presumes that everything done to Armenians was motivated by racial hatred. Hence, Azerbaijan's preliminary objection last week. This ratione materiae question does not arise this week, because Armenia has made no equivalent objection to Azerbaijan's case, and rightly so, because Azerbaijan's case was carefully framed to avoid that fault. Azerbaijan wishes to make clear to the court during this week the crucial differences between the CERD cases brought by Armenia and Azerbaijan respectively, especially for purposes of jurisdiction. The myriad claims that comprise Armenia's case, as you heard last week and can see from Armenia's memorial, are rooted in the conduct of armed hostilities and their immediate aftermath. They are bound up with questions about the applicability of international humanitarian law between belligerent states, which Armenia tries to shoehorn into its CERD complaint. Turning to Azerbaijan's CERD case, the legal position of an occupying power is fundamentally different. Armenia was the occupying power in Karabakh for 3 decades. As such, it had international responsibility for public order and safety throughout the territory. That included responsibility for compliance with the CERD. And yet, far from securing that compliance, Armenia used its occupation to mount a wide-ranging, sustained and systematic campaign of ethnic cleansing and cultural erasure against Azerbaijanis. As Azerbaijan reported to the CERD Committee in 2005, and I quote, "As a result of Armenian aggression and ethnic cleansing, there are now some 1 million refugees and displaced persons in Azerbaijan," close quote. The extent and nature of Armenia's efforts to impose and maintain ethnic purity throughout the parts of Azerbaijan that it illegally occupied started to become clear only in 2020, when many of the obstacles placed by Armenia to the gathering of evidence were overcome by Azerbaijan's liberation of large parts of the formerly occupied territory. Hence the timing of Azerbaijan's application to the court the next year, in 2021. Mr. President, members of the court, this is a paradigmatic case of racial discrimination perpetrated on a mass scale of precisely the kind that the CERD was put in place to prevent. As the preamble to the Convention provides, the states parties are resolved to prevent and combat racist doctrines and practices. Such doctrines and practices lie at the heart of Azerbaijan's complaint. Armenia's case, by contrast, contains in large part a plethora of individual actions allegedly committed during armed hostilities. Mr. President, members of the court, I thank you for your attention and ask that you now call on Professor Vaughan Lowe, King's Counsel, who will address you on jurisdiction ratione temporis.
I thank Mr. Fietta for his statement. I now invite Professor Vaughan Lowe to take the floor. You have the floor, sir.
Thank you. Mr. President, members of the court, it's a privilege to appear before you and an honour to have been entrusted with this part of Azerbaijan's submission. I shall address Armenia's first objection that Azerbaijan's claims relating to the First Karabakh War, which ended in 1994, are outside the jurisdiction of the court ratione temporis. The court will recall that Armenia acceded to CERD on the 23rd of June 1993, and Azerbaijan acceded on the 16th of August 1996. And in accordance with Article 19, the Convention entered into force for each of them 30 days after its accession. CERD thus entered into force for Armenia on the 23rd of July 1993, and for Azerbaijan on the 15th of September 1996. It's common ground that the court has no jurisdiction over matters prior to July 1993, and Azerbaijan makes no such claims. It's also agreed that the court does have jurisdiction in respect of Azerbaijan's claims relating to the period after September 1996. Thus, when Armenia says that, quote, the court's jurisdiction ratione temporis under Article 22 of the CERD does not and cannot extend to the period prior to its entry into force between the parties on the 15th of September 1996, the jurisdictional dispute is in fact confined to a 38-month period between July 1993 and September 1996, and it covers only a part of Azerbaijan's claims. Azerbaijan's position on this comes down to three propositions. First, there is a distinction between, one, the question of the date on which the court has jurisdiction and is seized of a dispute, and two, the question of the dates of the facts that the court can adjudicate upon in the exercise of that jurisdiction. One might call it the distinction between the temporal scope of procedural rights and duties related to dispute settlement procedures, and the temporal scope of substantive rights and duties under the CERD. And here the dispute concerns only the latter. The court certainly had jurisdiction over at least some of Azerbaijan's claims and was seized of the dispute when Azerbaijan filed its application in 2021. Second, Azerbaijan says that the court can exercise its jurisdiction ratione temporis over claims that Armenia breached its substantive obligations under the CERD in respect of any conduct occurring on or after the 23rd of July 1993, the date on which those substantive CERD provisions entered into force for Armenia. Third, even if the 15th of September 1996 were the critical date, as Armenia argues, quod non, all of Azerbaijan's claims would still be within the court's jurisdiction ratione temporis. Jurisdiction over Armenia's breaches of CERD obligations originating in conduct after the 15th of September 1996, the cultural and environmental destruction are examples, is not contested. And while some of the breaches may have begun between 23 July 1993 and 15 September 1996, they are what the International Law Commission has characterized as continuing or composite breaches of international law, which extend in time and remain breaches after 15 September 1996. All of these propositions are straightforward, and all will be well known and understood by the court, because they concern questions that have arisen and been decided by the court before. Armenia provides 5 grounds or arguments for its jurisdictional objections concerning the period from July 1993 to September 1996, but each is without foundation and should be rejected. Armenia's first ground is that CERD Article 22, by referring to disputes between 2 or more states parties with respect to the interpretation or application of the CERD, quote, makes clear that it does not apply to acts or facts that preceded the CERD's entry into force as between the states parties concerned, end quote. But CERD Article 22 doesn't say any such thing, either clearly or obscurely. Armenia is imposing its own interpretation upon Article 22. Armenia suggests that its interpretation of Article 22 is supported by the principle of the non-retroactivity of treaties, reflected in Article 28 of the Vienna Convention on the Law of Treaties. But that is incorrect. VCLT Article 28 reads as follows. Unless a different intention appears from the treaty or is otherwise established, its provisions do not bind a party in relation to any act or fact which took place or any situation which ceased to exist before the date of entry into force of the treaty with respect to that party. As you can see, VCLT Article 28 does not refer to the date of entry into force as between the states parties concerned. It refers to the date of entry into force of the treaty with respect to that party, in this case, Armenia. And the passages quoted by Armenia from the work of the ILC on what became VCLT Article 28 are directed at a different point, that the substantive provisions of a treaty cannot bind a state before it has acceded to the treaty, and the non-retroactivity principle, therefore, precludes the use of a dispute settlement clause in the treaty in respect of claims relating to acts and omissions prior to the alleged wrongdoing state's accession. And we invite you to read all 5 paragraphs of the ILC commentary on what was then numbered Draft Article 24. The key point is that retroactivity is relevant in 2 distinct contexts. Procedurally, where the question is, did the states consent to the court's jurisdiction at the material time? And substantively, where the question is, was the state bound by a substantive provision of the CERD at the material time? And the material times are different. The answer to the procedural question is clear. It's an elementary principle of international law that the jurisdiction of international tribunals derives from the consent of states parties to submit a particular dispute to the tribunal as of the date on which the dispute settlement mechanism is invoked. Azerbaijan could invoke the dispute resolution clause in the CERD and file an application in respect of a dispute with another state party to the CERD at any time following the date on which the convention came into effect for Azerbaijan and that other state party. The court's jurisdiction depends on the consent of the parties on the date that the dispute is put before it. In this case, both parties had consented to the court's jurisdiction by 15 September 1996, and the court's jurisdiction was actually invoked by Azerbaijan's application 25 years later, on the 23rd of September 2021. There is no element of retroactivity here. The dates of the alleged violations of substantive provisions of international law is an entirely separate point. This was established in the Bosnian genocide case. There, Yugoslavia, like Armenia here, argued that the court, once seized, could only deal with events subsequent to the date on which the Genocide Convention became applicable as between the parties. The court held, however, that the Genocide Convention, and in particular its compromissory clause in Article 9, does not contain any provision which limits the court's jurisdiction ratione temporis in that way, nor did the parties make any reservation to that effect. Therefore, the court had jurisdiction to adjudicate on the application of the Genocide Convention to facts which occurred prior to the Convention entering into force between the parties. And the same is true in respect of Article 22 of the CERD. It contains no limitation ratione temporis confining the court's jurisdiction to facts or situations arising after a certain date, nor has either party purported to make any reservation having a similar effect. Complaints of breaches that have arisen out of facts occurring during or in relation to the First Karabakh War are within the jurisdiction of the court once it became validly seized. That is, of course, not to say that the court can treat the substantive provisions of the CERD as if it had always been in force for both Armenia and Azerbaijan. Obviously, no state party can be bound by a treaty provision that has not entered into force for it. And I turn to that question next. The substantive question is whether Armenia was, at the material time, the time when the conduct complained of occurred, obliged to act in a certain way. Armenia accepted yesterday that it was bound to comply with the provisions of the CERD from 23 July 1993, when the CERD entered into force for Armenia. Azerbaijan was well aware of the importance of questions of temporal jurisdiction and has deliberately not presented any claims based on atrocities committed by Armenia prior to 23 July 1993. All of Azerbaijan's claims arise after the 23rd of July 1993, when Armenia became bound by the CERD. Indeed, in its memorial, Azerbaijan separated out the facts occurring before and after 23 July 1993, so that it is clear what facts can give rise to operative breaches by Armenia of the CERD. Where Azerbaijan's memorial refers to events before 1993, it does so only as background, in order to cast light on the context and as evidence of Armenia's purpose in carrying out its post-1993 breaches of the CERD. This is consistent with this court's guidance in Croatia-Serbia, where it said that, quote, what happened prior to 8th October 1991, the critical date in that case, is pertinent to an evaluation of whether what took place after that date involved violations of the Genocide Convention. So Azerbaijan's case involves no retroactive application of the CERD. In Belgium, Senegal, the court held that the principle of non-retroactivity is satisfied whenever a convention is applied to facts having occurred after its entry into force for the state concerned, as opposed to acts that took place prior to the entry of the convention into force for that state. The erga omnes partes and jus cogens character of the obligations under the Third and similar treaties supports the principle that those obligations are engaged for every party from the date that the treaty comes into force for that party. And the court's reasoning in Belgium-Senegal is again on point. Obligations in conventions, such as the Convention Against Torture in that case, or the Third in the present case, are owed to all states parties. It's not a matter of reciprocity or of the standing of particular states parties. As the court has said, the, quote, contracting states do not have any interests of their own. They merely have, one and all, a common interest, namely the accomplishment of those high purposes which are the raison d'etre of the convention, end quote. Ratifications of conventions of this kind are binding commitments to observe the convention rules, and any state party can call out those who break the commitment. Armenia has known for over 30 years that another state party could bring a claim against it, and it knew that when it chose to ratify the Third. Indeed, the point goes further. In its 2012 judgment in the Nicaragua-Colombia case, the court held that in light of the object and purpose of the UN Convention on the Law of the Sea, which was to establish a legal order for the oceans, Colombia was entitled to invoke Nicaragua's obligations as a state party to the UNCLOS, even though Colombia itself never became a party to the UNCLOS. There's no question of retroactivity in the present case because the relevant conduct underpinning Azerbaijan's claims of breach occurred after Third's entry into force for Armenia in 1993. I turn to the third point, the relevance of continuing and composite breaches of international law. Mr. Martin referred yesterday to discrete acts or omissions constituting immediate breaches or simple breaches of international law. The ILC called them completed acts, a violation of a state's airspace and a violation of the immunity of a diplomat are examples. Mr. Martin, seeking to make a point about exactly when a breach occurs, contrasted them with composite acts, where cumulative or aggregated conduct constitutes the essence of the wrongful act. Apartheid is different in kind from individual acts of racial discrimination, he said, rightly. But the relevant contrast here is not between completed acts and composite acts, but between completed acts and continuing acts, such as unlawful occupations of territory or continuing failures to fulfill a duty to bring an end to racial discrimination. As the ILC said, quote, conduct which has commenced sometime in the past and which constituted, or if the relevant rule had been in force for the state at the time, would have constituted, a breach at that time can continue and give rise to a continuing wrongful act in the present. End quote. And that is the situation here. Armenia's continuing failure to take steps to eradicate racial discrimination and organizations based on ideas of racial superiority, for example, may have begun years before it ratified CERD, but as the ILC put it, the breach of an international obligation by an act of a state having a continuing character extends over the entire period during which the act continues and remains not in conformity with the international obligation. Composite acts are just one kind of continuing act. A single isolated refusal on grounds of race to allow a person access to a public park is a completed act in breach of the third. But a sustained practice of refusing access on racial grounds is a composite act. It is apartheid. It arises from a series of actions or omissions defined in aggregate as wrongful. And as the ILC explained, a composite act, quote, extends over the entire period starting with the first of the acts or omissions of the series and lasts for as long as these acts or omissions are repeated and remain not in conformity with the international obligation, end quote. Mr. Martin obscures that point by referring repeatedly to the date of crystallization of composite acts. But that's looking at the wrong end. That is when the composite breach starts. But the important point here is that the breach continues and lasts for as long as these actions or omissions are repeated. Azerbaijan's claims point to two aspects of Armenia's conduct. First, all of the Armenian acts and omissions of which Azerbaijan complains either originated after 23 July 1993 or they continued after 23 July 1993, the date on which the CERD entered into force for Armenia. None of Armenia's claims alleges a breach of international law that was completed before July 1993. Second, Azerbaijan says that Armenia's cumulative or aggregated acts and omissions amount to a practice of ethnic cleansing which, like apartheid, is itself a distinct breach of the CERD. If Armenia wants a definition of the elements of the delict, one might start with that framed by the UN Commission of Experts. Quote, a purposeful policy designed by one ethnic or religious group to remove, by violent and terror-inspiring means, the civilian population of another ethnic or religious group from certain geographical areas, end quote. Azerbaijan says that Armenia expelled Azerbaijanis from their homes, incited hatred towards them, destroyed their cultural heritage and public buildings in order to deprive them of a homeland and a base for their culture, and then mined and booby-trapped their homes in order to prevent them returning. That is what Azerbaijan understands by ethnic cleansing, a wholesale repudiation of all of the principles that the CERD was established to secure. It's more than the sum of its parts, and as a continuous and continuing policy and pattern of behaviour, it is a violation of the CERD. As I noted earlier, the dispute over the court's jurisdiction, ratione temporis, is limited to a contested period of 38 months. In fact, even that overstates the case. Even if the court were to accept Armenia's argument that the critical date in this case is the date of CERD's entry into force for Azerbaijan, 15th September 1996, rather than July 1993, Azerbaijan's claims still remain within the court's jurisdiction. Acts and omissions fall outside the temporal scope of the court's jurisdiction only if they were completed before the date of the entry into force of the treaty for the acting state. The ongoing and systematic nature of Armenia's claim of ethnic cleansing, spanning 3 decades, can in no sense be considered to have been completed before September 1996, let alone before July 1993. Mines and booby traps were still being laid within the past 4 years. All of Azerbaijan's claims are based on acts or omissions that either occurred or continued after the 15th of September 1996. And Azerbaijan's submissions in paragraph 97 of its application and paragraph 591 of its memorial are to be understood in that light. These are continuing breaches. Azerbaijan's claims and the dispute under Article 22 relate to conduct that occurred when both states were party to the Convention. And again, in its memorial and observations on Armenia's preliminary objections, Azerbaijan has identified the breaches of the CERD which occurred or extend after the 15th September 1996 date for which Armenia contends. I can deal with Armenia's other arguments more swiftly because they all derive from the mistaken analysis of the temporal limitations that I've tried to unpack this morning. Armenia's second objection is that the third parties never intended its parties to be applied retroactively. But they're not being applied retroactively. The substantive obligations run from the date the treaty is binding on the offending state, and the procedural rights and obligations under Article 22 run from the date that the treaty is in force between both state parties. And that perhaps explains why no states have considered it necessary to make reservations concerning the retroactive application of the CERD. It obviously cannot be applied retroactively to events occurring prior to their becoming bound by the CERD. Armenia's third objection, that CERD Article 22 cannot be understood to confer rights on states corresponding to a time during which they were not parties to the CERD, is no more than another rewording of the same point, and it has the same answer. The CERD does not confer rights on states before they became parties to it. Azerbaijan gained the procedural right to invoke the CERD through the dispute settlement mechanism in Article 22 only when Azerbaijan became a party to the CERD, and the CERD entered into force for it. The substantive provisions are not conditional on the compromissory clause, but are rather dependent on the date on which the offending state entered into the CERD, and the CERD became effective for that state. Armenia was obliged to comply with the CERD from the 23rd of July 1993, when the CERD entered into force for it. The suggestion that Azerbaijan's interpretation, quote, would open up a vast universe of potential historic claims and even create reluctance to include provisions giving jurisdiction to the court in future treaties, is Armenia's fourth objection. And the answer to this is that no claims can ever arise in respect of any conduct occurring before the CERD entered into force for its first 27 parties on the 4th of January 1969, or the later dates on which it took effect for each of the other 155 parties. For example, Angola and Dominica acceded to the CERD in 2019. No case could be brought against them under the CERD for any alleged breach of the CERD occurring before 2019. The CERD's been in force for more than half a century, and the court has so far had cases emanating from only 4 situations: Ukraine-Russia, Georgia-Russia, Qatar-UAE, and Azerbaijan-Armenia. This is hardly a vast universe of historic claims. Armenia's fifth and final objection is that extending the application of Article 22 to events prior to the entry into force of the CERD as between itself and Azerbaijan would ignore the element of reciprocity inherent in compromissory clauses. And again, there is a simple answer. There is no reference at all to reciprocity in CERD Article 22 of the kind that is present in Article 36.3 of the Court's statute. Armenia says, quote, whenever a compromissory clause is contained in an international agreement, in accordance with Article 36.1, it applies obviously to all the parties concerned in a like manner, end quote. And that is plainly correct. And it doesn't advance Armenia's case. It's necessary to separate the substantive and procedural questions. Reciprocity only goes to the question of whether or not there is mutual consent between the parties to the ICJ's jurisdiction under Article 22. Azerbaijan accepts, of course, that Article 22 applies to all third parties in a like manner. But it's sufficient for reciprocity purposes that both states' parties could file claims under Article 22 after September 1996, as indeed both parties have done. And as for Armenia's curious observation that if Azerbaijan were right, that would mean that Armenia would be entitled to present counterclaims in this case, let it do so. Why has it not done so already? There doesn't need to be identity in terms of the critical date for the application of substantive obligations under a treaty in order for there to be reciprocity over the ability to bring claims under the compromissory clause. All multilateral treaties that remain open for accession by other states necessarily contemplate that some states will become bound by substantive obligations earlier than others. That is how multilateral conventions work. As the Court itself has said, in a convention of this type, one cannot speak of individual advantages or disadvantages to states, or of the maintenance of a perfect contractual balance between rights and duties. For all these reasons, Azerbaijan's position is that the Court can dismiss Armenia's ratione temporis objection now. If, however, the Court wishes to hear Azerbaijan's case pleaded out before it decides the question definitively, then the matter will require detailed consideration of the facts and evidence in the case, only some of which Armenia has addressed. And in such circumstances, the question would not have an exclusively preliminary character and could not be resolved at this preliminary objection stage of the proceedings, not least because Azerbaijan's claim is not that each of a host of individual acts and omissions constituted a breach of the CERD, but rather that Armenia was engaged in a systematic pattern and practice of discrimination contrary to the CERD, evidenced by the aggregate of its conduct over an extended period of occupation. Armenia accepts that the Court has jurisdiction over post-1996 conduct. There is no suggestion that the whole of Azerbaijan's claims fall outside the Court's temporal jurisdiction. And only when the evidence is considered can it be finally decided if any individual facts must be disregarded, and if so, what the effect on Azerbaijan's case might be. That is a matter for the hearing on the merits. Azerbaijan's respectful submission is, therefore, that for the reasons that I've set out, Armenia's preliminary objections to the Court's jurisdiction, ratione temporis, fall to be dismissed. Mr. President, members of the Court, this concludes my submissions. I thank you for your attention and ask that you now call on Professor Stefan Talman, who will address you on the issue of admissibility.
I thank Professor Lowe for his statement. I now invite Professor Stephen Talman to take the floor. You have the floor, sir.
Monsieur le Président, Madam Vice President, distinguished members of the Court. My task today is to respond to Armenia's admissibility objection. Armenia here simply recycles and repackages its objection to the Court's jurisdiction, ratione temporis, under a different heading. Let me note at the outset that Armenia's admissibility objection is of limited scope. Armenia does not object to the admissibility of Azerbaijan's application as a whole, but only to what it calls Azerbaijan's historical claims. That is, claims based on events before 15 September 1996. Even if this objection were upheld, it would bring the proceedings to an end only with respect to these specific claims. However, as Professor Lowe has shown, Azerbaijan's claims cannot be neatly separated into claims pertaining to events before and after 15th of September 1996. Many of the claims concern continuing or composite violations of the third, which began before 15 September 1996 and continued thereafter. Whether there are any self-contained claims prior to 15 September 1996 will invoke an examination of the substance of the claims and thus be a question for the merits. No such examination will be necessary, however, as Armenia's admissibility objection already fails on legal grounds. Armenia puts forward two arguments. First, it alleges that Azerbaijan's purported delay in asserting its historical claims was detrimental to Armenia. And second, that these claims supposedly created procedural inequalities between the parties. Mr. President, let me begin with the allegation that Azerbaijan's purported delay in bringing its claims was detrimental to Armenia. Before addressing this argument, let me note at the outset that Armenia itself brings numerous claims with regard to events between the late 1990s and 2005. Armenia first raised these claims in November 2020, but it seems to have no problem with a delay of more than 23 years here. But as we heard yesterday, what is sauce for the goose is sauce for the gander. Azerbaijan did not object to the admissibility of these claims because delay is not an issue in the present case. It is correct that the court recognized in the Nauru case that, I quote, delay on the part of the claimant state may render an application inadmissible, end quote. But the court immediately went on to note, and I quote again, international law does not lay down any specific time limit in that regard. It is therefore for the court to determine in the light of the circumstances of each case whether the passage of time renders an application inadmissible. End of quote. Inadmissibility must thus be determined in the light of the circumstances. The circumstance seized upon by Armenia is whether the respondent state has been seriously disadvantaged by a delay. As the International Law Commission noted in its commentary to the articles on state responsibility, and I quote again, the decisive factor is whether the respondent state has suffered any prejudice as a result of the delay, in the sense that the respondent could have reasonably expected that the claim would no longer be pursued. End of quote. There is no basis on which Armenia could have developed a reasonable expectation that Azerbaijan would no longer pursue its claims. The mere passing of time does not give rise to such an expectation. Azerbaijan regularly made Armenia aware of its grievances with regard to the subject matter of CERT. For example, in August 1993, shortly after Armenia acceded to CERT, Azerbaijan accused it of ethnic cleansing. Azerbaijan also stated that full responsibility for the consequences of the said actions is borne by officials in the Republic of Armenia. As there were no diplomatic relations between the parties, these grievances were conveyed in letters to the United Nations. Azerbaijan regularly asked for these letters to be circulated as UN documents. These letters did not go unnoticed, as Armenia responded to some of the accusations in letters of its own. Like in the Nauru case, Armenia was thus aware of Azerbaijan's grievances throughout all these years. That Azerbaijan did not expressly refer to the CERT in these letters could not give rise to a reasonable expectation that no claims for the grievances would be pursued. As the court noted in Georgia versus Russia, an express reference to the treaty is not required to bring the matter under CERT. What is important is that the grievances raised relate to the subject matter of the treaty. There is no subject matter more clearly within the CERT than ethnic cleansing. Armenia also claims that a reasonable expectation was created because Azerbaijan allegedly had all the material to bring a claim upon its accession to the convention in 1996, but did not do so. However, this is incorrect. Azerbaijan only learned of the full extent of the CERT violations and was only able to gather the necessary evidence for bringing the present claims in November 2020, upon liberating its territory that had been under Armenian occupation since 1994. It must be remembered that neither Azerbaijan nor the United Nations had access to the occupied territory before. Armenia is deliberately trying to reduce Azerbaijan's claims to forcible expulsion by claiming that testimonies of the displaced persons could have been secured since the 1990s. Azerbaijan's claims, however, also encompass the deployment of landmines and booby traps in civilian areas, environmental degradation and cultural erasure. To prove these violations, physical access to the formerly occupied territory was essential. It is also wrong to state, as Armenia did, that Azerbaijan's memorial draws only on documents available for years. As a quick perusal of the memorial will show, there are numerous references to material that has become available only after the liberation of the territory. Mr. President, Armenia tries to introduce disadvantage as another separate circumstance to be considered when determining whether the passage of time renders an application inadmissible. The ILC, however, assumed that the respondent state was disadvantaged only if it could reasonably have expected that the claim would no longer be pursued. In any case, there is no disadvantage on the part of Armenia. Armenia's access to witnesses and documentary evidence is a non-issue here. According to the jurisprudence of the court, it is the party which alleges a fact in support of its claims to prove the existence of that fact. In the present case, it thus falls to Azerbaijan to submit the relevant evidence to substantiate its claims. In any case, Armenia, being aware of Azerbaijan's grievances, would have had 26 years of occupation to collect all the relevant evidence for its defense. In addition, it must be recalled that Azerbaijan fully liberated the occupied territory only in September 2023. Armenia thus had 2 years since the filing of the present claims to gather evidence in the territory still under its control. Mr. President, members of the court, I can be brief with regard to Armenia's second argument that the historical claims are inadmissible because they would create a procedural inequality between the parties. It is argued that while Azerbaijan could submit claims under cert pertaining to facts prior to 15 September 1996, Armenia could not submit counterclaims with regard to these facts. However, this is not a question of admissibility, but a consequence of the court's rules on counterclaims, requiring that the counterclaim comes within the jurisdiction of the court. This is not the first case where the court finds that its jurisdiction is not limited to, I quote, facts subsequent to the date when the convention became applicable between the parties, end quote, thus allowing one of the parties to bring a claim with regard to these facts. This is also not a question of procedural inequality, but a consequence of the operation of the substantive law. A state is bound by a treaty only from the date it has become a party to the treaty. The fact that Armenia has been bound by cert for some 3 years longer than Azerbaijan has nothing to do with procedural equality or the good administration of justice, but is a consequence of states being free to decide when to become a party to a multilateral treaty. The procedural equality of the parties under cert is guaranteed by Armenia and Azerbaijan being able to institute proceedings against each other under Article 22 only from the moment that there are both parties to the Convention. Let me conclude. There is no legal basis for finding that Azerbaijan's claims would be inadmissible. First, Armenia has not suffered any prejudice in the sense that it could have reasonably expected that the claims would no longer be pursued. Second, Armenia is in no way disadvantaged. Third, there is no question of procedural inequality between the parties. For those reasons, Armenia's admissibility objection should thus be dismissed. I thank the Court for its kind attention, and Mr. President, it may now be a convenient time for a short break. Otherwise, I may ask you to call on Mr. Wordsworth to respond to Armenia's second preliminary objection.
I thank Professor Talman for his statement, and before I invite the next speaker to take the floor, the Court will observe a 10-minute break. The sitting is suspended. Please be seated. The sitting is resumed. I now invite Mr. Samuel Wordsworth to address the court. You have the floor, sir.
Thank you, sir. Mr. President, members of the court, I'll be dealing with Armenia's misconceived objection ratione materiae concerning what it calls Azerbaijan's claims and contentions concerning landmines and booby traps. And I start by making two responsive points on the applicable legal test. First, Armenia seeks inappropriately to turn Article 1.1 into a rigid two-step test, pursuant to which the court should, it is said, ask whether there is a distinction, exclusion or preference which is based on race, colour, descent or national or ethnic origin, and only if so, ask whether that distinction, exclusion or preference has had the purpose or effect of nullifying or impairing the equal recognition, enjoyment or exercise of human rights and fundamental freedoms. This interpretation then feeds into a broad brush and notably simplistic argument, which you heard repeated yesterday, that Azerbaijan's case on landmines and booby traps inevitably fails because these are indiscriminate weapons that are incapable of making a distinction based on national or ethnic origin. That makes no sense at all because, of course, all depends on how and for what reason any given weapon is being used. And consistent with this basic observation, it should be obvious that the question of purpose or effect may shed light on the question of whether the impugned measure is based on national or ethnic origin or vice versa. Unsurprisingly, and notwithstanding Armenia's current contentions, the Qatar and UAE case does not suggest the contrary, while in its recent judgment in Ukraine and Russia, the court demonstrated how the stated purpose or the effects of a measure may show that it is based on a prohibited ground, explaining, as you can see in the last sentence on your screens, racial discrimination may result from a measure which is neutral on its face, but whose effects show that it is based on a prohibited ground. Thus, the court provides an example of how the two elements of Article 1.1 do interrelate, and there is no assistance to be gained from Armenia's inaccurate suggestion of a rigid two-step approach. Second, it still has to be emphasised that there is no test of plausibility to be applied at the jurisdictional phase. The court could scarcely have made this more clear in the Ukraine and Russia case concerning the ICSFT. At the provisional measures phase, the court rejected Ukraine's request on the basis that it had not put forward a plausible case on the requisite mental element, that is, knowledge or intent. By contrast, in its subsequent judgment on preliminary objections, the court explained that at the present stage of the proceedings, an examination by the court of the alleged wrongful acts or of the plausibility of the claims is not generally warranted. Russia's objections, ratione materiae, were then rejected without any consideration of plausibility at all, with the court's basic position being that questions largely of a factual matter were properly for the merits. It was therefore a little surprising to see again yesterday, just as in Armenia's written objections, a repeated reliance on the findings on plausibility in the orders of December 2021 and February 2023, with just an assertion as to these being highly relevant, and without any close focus into what the court was actually saying. Looking then at paragraph 53 of the December 2021 order, on which Armenia has placed such great weight, the court explains, and I will take this in stages, with regard to rights under CERD asserted by Azerbaijan with respect to Armenia's alleged conduct in relation to landmines, the court recalls that Azerbaijan claims that this conduct is part of a long-standing campaign of ethnic cleansing. The court recognises that a policy of driving persons of a certain national or ethnic origin from a particular area, as well as preventing their return thereto, can implicate rights under CERD, and that such a policy can be effected through a variety of military means. And pausing there, that is a correct reflection of how Azerbaijan puts its case. And it is a statement useful to the court at this jurisdictional phase as to how such a case can implicate rights under CERD. In other words, the case relevant to landmines, as correctly identified by the court, concerns a long-standing campaign of ethnic cleansing, effected through a variety of military means, that is indeed capable of having an adverse effect on the enjoyment of certain rights protected under the CERD. It was puzzling that yesterday Mr. Salanidis should spend so much time seeking to persuade you that Azerbaijan, by contrast, has a wholly freestanding claim of breach of CERD in relation to landmines and booby traps, without taking you to either how the claim is put in Azerbaijan's memorial or how the court itself has understood the claim. I'll return to that point in a moment. The court's order then continues. However, the court does not consider that CERD plausibly imposes any obligation on Armenia to take measures to enable Azerbaijan to undertake demining or to cease and desist from planting landmines. This is concerned with the plausibility of obligations of Armenia with respect to the specific interim remedies that were being sought by Azerbaijan at paragraphs A and B of its request for provisional measures. The current issue, by contrast, is whether an act or subset of acts, here planting landmines and booby traps, is capable of forming part of a broader systematic practice, ethnic cleansing, in breach of a given treaty. The court is no longer concerned with remedies, the availability of which is not decisive of whether CERD may be engaged. Turning to the final sentence in this passage, Azerbaijan has not placed before the court evidence indicating that Armenia's alleged conduct with respect to landmines has the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of rights of persons of Azerbaijani national or ethnic origin. This is concerned with plausibility by reference to the evidence then before the court. But now the court is assessing jurisdiction, not considering plausibility and specific interim remedies, and by reference to the facts as they have developed. On its past jurisprudence, it would plainly be inappropriate to determine in the course of preliminary objections that a state cannot assert rights that are capable of falling within a given treaty. And this is all the more so when the court has already indicated that a policy of driving persons of a certain national or ethnic origin from a particular area, as well as preventing their return thereto, can implicate rights under cert, and that such a policy can be effected through a variety of military means, which must, in principle, include the laying of landmines and booby traps. This takes me to the question of what Azerbaijan is in fact claiming, a claim that has been correctly understood by the court as concerning a long-standing campaign of ethnic cleansing, with the conduct of laying mines and booby traps being the means of achieving ethnic cleansing, rather than breaches of the cert per se. As the court will recall, the relevant claim of Azerbaijan is as stated at paragraph 591A of its memorial in its submissions. Armenia, through its state organs, state agents, and so on, is responsible for violations of Articles 2 to 7 of CERD by the following actions. A, the ethnic cleansing and cultural erasure of Azerbaijanis from the then occupied territories and establishment of an ethnically pure Armenian settlement in those territories, including by, and then you see the relevant sub-provision dealing with the conduct, barring of Azerbaijanis from access to the then occupied territories, and from Armenia, including frustration of the right of internally displaced Azerbaijanis and Azerbaijani refugees to return home. There are then 4 other instances in which Azerbaijan alleges that there has been a separate breach of Articles 2 to 7 CERD, as listed out at subparagraphs 5911B to E, concerning the promotion of hatred and the like, none of which is subject to ratione materiae objections by Armenia. There are 3 points to draw out. First, the relevant claim at paragraph 591A is one of breach through ethnic cleansing and cultural erasure. There is no separate plea for breach with respect to the laying of landmines and booby traps. This is merely part of the conduct on which Azerbaijan relies to demonstrate ethnic cleansing and cultural erasure, and it is not even conduct that is expressly mentioned within the submissions. It merely falls within the broader conduct of barring access to the formerly occupied territories at subparagraph 4. Armenia spent a good deal of time yesterday trying to persuade you of the contrary, suggesting, for example, that because Azerbaijan had used the term landmine 73 times in its memorial, there must be a discrete claim in relation to landmines, and taking you to isolated passages from pleadings and oral submissions to the same end. We refer to how the claim is in fact put in the formal submissions, and ask you, insofar as considered necessary or helpful, to refer to passages from past oral submissions that you were not taken to yesterday, but which are reflected in how the court itself understood Azerbaijan's case in its prior orders. And another useful reference to that effect is paragraph 22 of the December 2021 order, where the court summarized as follows. Azerbaijan specifically alleges that following the end of the 2020 conflict, Armenia actively continues to prevent the return of displaced ethnic Azerbaijanis to the areas formerly under Armenian control by refusing to share information about the minefields in the area where their former homes were located, so as to allow for mine clearance operations, and by continuing to plant new mines on Azerbaijan's territory. Azerbaijan considers that the applicant's conduct in this regard is a continuation of Armenia's decades-long ethnic cleansing campaign against persons of Azerbaijani national or ethnic origin. So whereas Armenia may wish to identify and seek to object to what it calls the claims and contentions concerning landmines and booby traps, this cannot be a valid jurisdictional objection. There is no jurisdictional objection ratione materiae to Azerbaijan's actual claim of ethnic cleansing. If the court has, as is accepted, jurisdiction over that claim, it has jurisdiction ratione materiae, full stop. Second, if Azerbaijan were considered as having individual claims for breach with respect to each of the individual lines of conduct listed at paragraph 591A, subs 1 to 4 of its memorial, it would make no difference. There is no jurisdiction objection with respect to the relevant conduct, that is subparagraph 4 on the barring of Azerbaijanis from access to the then occupied territories, including frustration of the right to return. The differing means by which the barring is said to have been achieved can only be a matter for assessment of the merits. However, it appears obvious that the barring of access, that is, steps taken to ensure that territory ethnically cleansed of Azerbaijanis remains ethnically cleansed, can be achieved through the laying of mines and booby traps. Third, it is not open to a respondent to accept the court's jurisdiction over a claim, but then to assert the existence of certain subdivisions of the claim with a view to seeking to persuade the court that individual aspects of conduct relied upon could not amount to a breach of cert. It is for the claimant state to formulate its claim as it chooses. If jurisdiction is not challenged in relation to the claim, but part of the conduct relied on is not considered by the respondent to be in breach or even capable of amounting to a breach, that is a matter for the merits. There is no provision in the court's statute or rules that allows for what is, in effect, the attempted striking out at the jurisdictional phase of one of many lines of allegation and evidence that a claimant submits in order to demonstrate the existence of a given breach. Indeed, it would be extraordinary if it were otherwise, as the court cannot be in a position to evaluate one element of conduct relied upon without seeing the entirety of the evidence relied upon with respect to the specific allegation of breach. Reliance was placed yesterday on the court's undoubted authority to determine the nature of the dispute before it in order to assess whether there is indeed a dispute as to interpretation or application of a given treaty. But that is of no relevance in the current context. A dispute as to whether there has been ethnic cleansing, or even as to whether there has been a barring of access and frustration of the ability to return, is plainly within cert, and this is not even contested. There is nothing in the court's jurisprudence to say that it must, or even could, go further and see whether, objectively, the actual claim could be dissected and substituted by a series of narrower claims, one of which could be said to be outside jurisdiction. The reference yesterday to Equatorial Guinea and France was notably unhelpful, as there the court was merely identifying that it did not have jurisdiction over one aspect of the dispute, that is, the claim insofar as it concerned rules of customary international law. Such rules were not incorporated by the specific treaty provision relied on by the claimant, namely Article 4 of the Palermo Convention. That is simply a matter of treaty interpretation, not the slicing up of a claim, as it was put by the claimant, into a series of subclaims made up of discrete allegations of fact. I turn now to say a few words on the more fact-based contentions made by Armenia. Armenia contends that even accepting Azerbaijan's factual allegations as true, Armenia's alleged use of landmines and booby traps would not constitute a distinction within Article 1.1 that is based on national or ethnic origin. It makes just 2 points. First, Armenia says that landmines and booby traps are indiscriminate by nature and are incapable of making a distinction based on national or ethnic origin. This appears facile and is moreover inconsistent with what Armenia is saying in its observations on Azerbaijan's objections. Like any weapon, landmines and booby traps are generally used in a targeted way and can thus be used to target specific groups of civilians based on national or ethnic origin. As such, it should be indisputable that landmines and booby traps can be deployed to pursue a program of ethnic cleansing. Second, and related to this, Armenia asserts that any placing of landmines was done exclusively for defensive military purposes and only along the line of contact between military forces. Well, that is Armenia's case. Azerbaijan challenges this, and for good reason, as we will come back to. For now, however, the point is that, unsurprisingly, it is not the practice of the court to approach jurisdictional objections on the basis that the assertions of fact by the respondent state are true. Mr. Oki will shortly take you to what the documents show so far as concerns landmines. That is, they provide a more than sufficient evidentiary basis for Azerbaijan's contention that the landmines Armenia planted were a critical element of its campaign to create and maintain an ethnically pure Armenian settlement on Azerbaijan's territory by barring the return of displaced Azerbaijanis. Once such factual allegations by the claimant are assumed as true on the face of the relevant documents, and it is to be recalled that Armenia last week advocated for a measurably weaker test than that, the allegations with respect to landmines, forming as they do part of a much wider case of ethnic cleansing, must inevitably be capable of falling within CERD. The same applies to the allegations with respect to booby traps, which Azerbaijan explains, by reference to specific evidence, were placed inter alia by Armenian forces in houses and villages to which Azerbaijanis would be returning. Armenia's contrary case that booby traps were planted only by civilians can only be resolved at the merits phase. In addition, just as in the ICSFT case between Ukraine and Russia, the question of whether alleged acts fall within the scope of the treaty is closely tied up with the mental element of the perpetrator, in this case the basis and purpose of the alleged acts. As the court explained in Ukraine and Russia, such fact and evidence-heavy matters are not suitable for consideration at a jurisdictional phase, and all the more so given that it is Armenia that knows precisely when and where and why it planted landmines, or whether Azerbaijan is right to say that Armenian forces planted booby traps. These are all matters for the merits. I conclude by dealing with 3 further points made by Armenia. First, it contends that even accepting Azerbaijan's factual allegations as true, Armenia's alleged use of landmines and booby traps did not have the requisite discriminatory purpose or effect. This makes no sense. Azerbaijan's case, to recall, is that the landmines Armenia planted were a critical element of its campaign to create and maintain an ethnically pure Armenian settlement on Azerbaijan's territory by barring the return of displaced Azerbaijanis. That is a factual allegation supported by evidence. If the allegation is accepted as true, then the existence of the requisite discriminatory purpose or effect is manifest so far as concerns jurisdiction, and all the more so in circumstances where there is no challenge to jurisdiction over the relevant third claim, which is of the attempted creation and maintenance of an ethnically pure Armenian settlement on Azerbaijani territory. Second, Armenia says that to the extent that the placement of landmines and booby traps could be said to specifically affect a particular group, that group could only be Azerbaijani nationals who are members of the armed forces. Yet that is mere assertion, and a self-serving one, as all depends on the disputed issues of where and why landmines and booby traps were planted. And the assertion is inconsistent with the evidence, such as the location of booby traps in civilian houses. Third, it was also said by Armenia yesterday that there could be no jurisdiction with respect to landmines or booby traps so far as concerns the court's 7th December 2021 order on provisional measures, which requires the parties to refrain from any action which might aggravate or extend the dispute. Armenia accepts the binding nature of the order and the corresponding jurisdiction of the court. However, it says that Azerbaijan cannot assert a claim for non-aggravation by virtue of conduct that did not justify the indication of the substantive provisional measures requested. It also says that there is anyway no evidence at all to support a case on breach. Neither point can be made good. Suppose that Azerbaijan is able to show on the merits that despite the court's order of December 2021, certain booby traps were later set by Armenian military personnel in civilian areas, or that Armenia's continuing refusal to provide reliable maps of its minefields and booby traps has led to further death or injury to civilians. Aggravation and extension of the dispute would appear clear. As to the facts, including as to the purpose and effect of Armenia's landmines and booby traps, and developments since the orders on provisional measures, with your leave, I will now hand over to Mr. Ochi. Mr. President, members of the court, that concludes my remarks, and I thank you for your attention.
I thank Mr. Worther for his statement. I now invite Mr. Sean Ogi to take the floor. You have the floor, sir.
Mr. President, members of the court, I will address Azerbaijan's evidence concerning landmines and booby traps. Yesterday, Mr. Salonides said nothing about this evidence, instead merely repeating Armenia's assertion that the placement of such weapons, to the extent that it was done by Armenia, was done exclusively for defensive purposes. According to Azerbaijan's evidence, as the Armenian forces withdrew from the territories liberated in November 2020, landmines were placed in locations such as agricultural fields, graveyards and gardens in order to inflict as much human loss as possible on the returning Azerbaijani population. It is also Azerbaijan's case that Armenia deliberately planted landmines and booby traps in Azerbaijani civilian areas, including after it had agreed to return those areas to Azerbaijan under the 2020 trilateral statement. In December 2020, the United Nations undertook an interagency mine action assessment and concluded that there were, quote, indications that some houses might have been booby-trapped, IED, as the Armenians withdrew, end quote. We have a copy of that report, which is not in the public domain, and we hope that Armenia will agree that it may be put before the court. In June 2021, the head of Azerbaijan's Mine Action Agency, known as ANAMA, a very well-respected Azerbaijani agency that has been operating for over 30 years, almost 30 years, with the support of the United Nations Development Programme, reported, and you can see this on the screen, most of the mines found outside of the former line of contact have been buried in fields utilised in the past 3 to 5 years for agricultural purposes. And ANAMA concluded that Armenia's forces deliberately mined these areas during the forced withdrawal. More recently, after almost 3 years of further demining activities, on the 12th of February 2024, ANAMA stated, "When we look at the statistics of mine actuation incidents, we can see that areas are heavily contaminated with mines, not only along the former line of contact, but also in residential areas, crop fields, riverbanks, forests, and cemeteries. 247 out of 345 victims of mine incidents after the Second Karabakh War were killed or received various bodily injuries in the areas away from the former line of contact." And there are various photos in your judges' folders at tab 7 to illustrate how, by way of example, landmines have been placed in a desecrated cemetery so as to explode when attempts are made to restore toppled gravestones. Is it really being said that this can only have been done for defensive purposes? Even by reference to the still incomplete picture that the court now has, there is important evidence of the planting of landmines to create and maintain an ethnically pure Armenian settlement on Azerbaijan's territory by barring the return of ethnic Azerbaijanis. And in this respect, on the screen, you can see from an updated map of minefields found by ANAMA and locations where mines have exploded, that these are not confined to the line of contact, which is marked by the brown diagonal lines running along the top and then down the east side, as is alleged by Armenia in its memorial. A little more orientation is needed on this map. The location of minefields found by ANAMA, based on records provided by Armenia, is indicated by solid red circles. Additional minefields found by ANAMA are marked in purple and by the symbol MF. Starting at the bottom of the map, the districts of Gubadli, Zangilan, and Jabreil were liberated during the Second Karabakh War. ANAMA has found numerous minefields in these areas, all far from the former line of contact, and in civilian areas where internally displaced Azerbaijanis once lived and were expected to return. And Azerbaijan contends that those mines were laid by Armenia's forces as they withdrew from those territories. Pursuant to the trilateral statement, Armenia's forces also withdrew from the districts of Kalbajar, Lachin, and Agdam in late 2020. Again, Azerbaijan contends that Armenia's forces laid landmines in civilian areas as they withdrew. And you can see that ANAMA has found minefields in the west of Kalbajar and Lachin districts away from the line of contact. Armenia had access to the city of Lachin and the villages of Sus and Zabuk until August 2022, when, pursuant to the trilateral statement, those settlements were returned to Azerbaijan. Azerbaijan's memorial contends that Armenian forces laid landmines and booby traps as they withdrew. That is, after the court's order of December 2021. Notably, Mr. Salanidis ignored this when he boldly asserted, Azerbaijan literally provided no evidence, not a single citation or source, to support an allegation that landmines and booby traps were placed since the 7th of December 2021. In this respect, you can see on your screens now 2 booby traps that were found in October 2022 in houses and other civilian buildings in the villages of Sus and Zapug. One set to blow up when a threshold is crossed, the other when a door is opened. Internally displaced Azerbaijanis once lived and worked in these buildings, and they were expected to return. As regards the second image, please note that nails have been packed around the explosive so as to inflict as much physical injury as possible. The court has seen these images before, but it's also important to understand the context in which these explosives were set. As recorded in a formal inspection in November 2022, quote, 23 out of 33 private residential houses, 122 ancillary buildings, libraries, elementary schools and store buildings in Sus village are fully and deliberately destroyed, plundered. In a further recent example, published on the 19th of April as one of ANAMA's regular updates on its demining activities, it stated that a significant amount of explosive material has been discovered in a farm-type building associated with a residential building. And ANAMA explained, improvised explosive devices, explosive materials, both electric and non-electric detonators, numerous explosive charges prepared for powerful explosions, as well as improved explosive devices installed using D1 hand grenades manufactured in Armenia were discovered on the site. And you can see that equipment on the screen. It's also important for the court to have firmly in mind Armenia's refusal to hand over maps of where mines and booby traps have been set, even following the cessation of hostilities. If the explosives really were just for defensive purposes, as Armenia contends, what possible justification could there be for Armenia not to hand over comprehensive and accurate information as to their placement after November 2020? To give something of an insight to this, on the 6th of April 2021, the Armenian Ministry of Foreign Affairs called Azerbaijan's request for landmine maps a, quote, fake agenda. That was plainly wrong, and the international community, including the Parliamentary Assembly of the Council of Europe, the European Parliament, and the OSCE Minsk Group co-chairs, continued to call on Armenia to release all maps. Armenia eventually shared a limited number of maps of around 97,000 landmines planted along certain sections of the former line of contact in the Agdam region. It did this only in June 2021 and only in exchange for the return of 15 detainees. At the time, Azerbaijan said, and this may be thought to have been stating the obvious, obtaining mine maps will save the lives and health of tens of thousands of our citizens, including mining workers, and accelerate reconstruction projects and the return of internally displaced persons. Nonetheless, Armenia's Prime Minister's position was as follows. Maps of mined areas have been provided to Azerbaijan. However, they want to give the impression we have given everything we have. However, this is not the case. Instead, a tiny part is provided. As the casualties continue to mount, including among Azerbaijani civilians who have returned, Azerbaijan called on Armenia repeatedly to provide all maps in its possession of where it set explosives. An updated list of such statements is included in your judges' folders at tab 8. Between July and December 2021, Armenia provided minefield records for a total of over 1,000 minefields containing around 390,000 mines its forces had placed along certain additional sections of the former line of contact, as well as records for just 8 minefields laid in Zangilan, Gubadli and Jabrail districts, all far from the contact line. Also in November 2021, following a fact-finding visit to the liberated territories, the Independent Permanent Human Rights Commission of the Organization of Islamic Cooperation reported that, quote, that there is, quote, sufficient evidence to conclude that purposeful measures were undertaken by the Armenian side to impede the return of hundreds of thousands of internally displaced persons desperately waiting to return to their homes in safety and dignity, including massive contamination of the liberated territories with mines and massive militarization of the occupied territories by laying multi-layer military obstacles. As to the utility of the limited maps that were provided by Armenia in 2021, Azerbaijan subsequently explained in a letter to the United Nations Secretary General, dated 24th of August 2022, once examined by field specialists, it turned out that the mine formularies were incomplete, covering only part of the liberated territories, and a significant part of them were unreliable, while others contained no information pertinent to demining. The practical utility of the records of the minefield maps handed over by Armenia is around 25%. In October 2022, ANAMA reiterated that about 55% of recent landmine explosions occurred in the territories outside the areas where maps were provided by Armenia. And this can also be seen from the map on the screen. In October 2021, Armenia's agent told this court, quote, "We stand ready to provide any more maps in our possession regarding minefields located behind the lines currently held by Azerbaijani armed forces, which now present solely humanitarian concerns," end quote. And despite its statements, including its statement to this court on the 31st of January 2023, that all maps in its possession have been handed over, maps for 13 minefields in Shusha and Lachin districts were subsequently provided in October 2023. Further, on the 25th of January 2024, Armenia announced that it was providing to Azerbaijan an additional 8 sets of records on the location of landmines. This statement is in your judges folder at tab 9 and also on the screen. Recently, after several publications by the Azerbaijani media about injuries received by citizens of the Azerbaijan Republic from a mine explosion, and in continuation of the agreement reached as a result of negotiations, the Republic of Armenia National Security Service resumed survey work among former NK military personnel, as a result of which 8 new records appeared. This, of course, begs the question why there had ever been any halt in gathering information from former NK military personnel, especially since Armenia has had to recognize that this is purely a humanitarian issue. And please do recall that landmines within the formerly occupied territories have caused 65 deaths and 287 injuries since November 2020, of which 50 deaths and 123 casualties were civilians. And this includes the deaths of 14 civilians and the maiming of 33 more since the court's order of the 22nd of February 2023. Further, as ANAMA explained in a statement of 12th of February 2024, which is in the judges' folders at tab 10, these 8 reports mainly consist of notes on the mine-planted areas covering the former contact line in Kalbajar region, and as regards this limited area, as it was before, the information in the recently submitted contours has been reflected inaccurately, unreliably, and incompletely. The analysis and processing of the contours defined that the information contained in the documents is not consistent with the real minefields. The reference coordinates are incorrect and useless. Anama also stated, in general, the contours submitted by the Armenian side cover part of the area along the former line of contact. Information about part of the line of contact passing through the territories of Hojavend, Tatar, and Guranboy districts, as well as the areas mined by the Armenian military units during the time they retreated in November 2020, has not yet been provided. I conclude. Azerbaijan has put forward more than sufficient evidence, which on its face shows that Armenia's forces placed landmines and booby traps in civilian areas, far from the former line of contact, setting these lethal devices in places from which Azerbaijanis had been displaced and to which they were expected to return. This can have had no defensive purpose. And likewise, Armenia's continued refusal to share complete and accurate information on the location of the minefields and booby traps long after the cessation of hostilities can have had no defensive purpose. This is why, as Mr. Wordsworth has explained, Armenia's conduct is put forward as an element of Azerbaijan's claim for ethnic cleansing. Mr. President, members of the court, I thank you for your attention. And may I ask that you call on Professor Poisson de Chazon.
I thank Mr. Ogi for his statement.
I now give the floor to Ms. Professor Laurence Poisson de Chazorne. Madam, you have the floor. Mr. President, Madam Vice President, members of the court, it is an honor to appear before you once again on behalf of the Republic of Azerbaijan. I shall address the last aspect of Armenia's second preliminary objection to the court's jurisdiction, ratione materiae, with respect to Azerbaijan's claims concerning discriminatory acts and omissions by Armenia, which caused destruction and degradation of the environment at the expense of the Azerbaijanis. Now, the court is not obliged at this stage to determine whether the wrongful acts perpetrated by Armenia violate the substantive provisions of the CERD. This court need only ascertain, and I quote, whether the actions or omissions of the respondent complained of by the applicant fall within the scope of CERD. This court also recently clarified in its judgment in Ukraine versus Russia that racial discrimination under Article 1, Paragraph 1 of CERD thus consists of 2 elements. First, a distinction, exclusion, restriction, or preference must be based on one of the prohibited grounds, namely race, color, descent, or national or ethnic origin. And secondly, such a differentiation of treatment must have the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of human rights. Now, it is in the light of this legal test that both establishing the court's jurisdiction and the definition of racial discrimination at Article 1, Paragraph 1 of CERD must be understood, and not in any other way, as Armenia argues. By way of introduction, allow me also to specify that Azerbaijan's claims concern acts of environmental destruction and degradation which constitute environmental racism. Mr. President, Members of the Court, against the backdrop of what I've just said, I shall now set out the reasons why the Court enjoys jurisdiction ratione materiae in light of the said with respect to Armenia's unlawful conduct in wreaking environmental destruction. I shall make 2 points. Firstly, Armenia's environmental destruction was discriminatory and based on ethnic or national origin. Secondly, Armenia's discriminatory environmental destruction has prejudiced the Azerbaijanis' ability to enjoy and exercise their human rights and fundamental rights. I shall now turn to the first of these points. In its preliminary objections, Armenia contends that the acts of environmental destruction of which Azerbaijan complains do not constitute discrimination based on national or ethnic origin. Now, as it is necessary to do so at this stage, allow me to remind you of the evidence presented by Azerbaijan in its memorial. Evidence which shows that the environmental destruction in this dispute is indeed based on the ethnic or national origin of the Azerbaijanis. Together, this evidence clearly shows that Armenia's racially discriminating purpose is obvious in the different treatment meted out to the Azerbaijani districts surrounding the Karabakh region. This treatment is very different to that reserved for areas inhabited by ethnic Armenians. During the illegal occupation of Azerbaijani districts, and the Karabakh region by Armenia, the Azerbaijanis were systematically denied access to national resources, such as water, owing to their ethnic or national origin, whilst Armenians were favoured. This targeted discrimination is not simply an allegation. Azerbaijan has provided solid evidence for its claims of direct discrimination and indirect discrimination. The report and the findings of the independent experts from the company Industrial Economics, evaluating the damage caused to the environment in the liberated territories, as well as the United Nations Environment Programme report, were examined in detail in Azerbaijan's memorial. Azerbaijan's memorial enumerates the acts of environmental destruction committed in the districts of Agdam, Fuzuli, Gubadli, Jabrail, Kalbajar, Lachin, and Zangilan. These 7 districts surround the Karabakh region. The Karabakh region had a predominantly Armenian population. The 7 districts, for their part, had predominantly Azerbaijani populations. Now, as you can see on the screen, if we consider the ethnic makeup of these districts, less than 1% of the total population is Armenians. These districts, therefore, cannot be considered Armenian. These districts, historically dominated by Azerbaijanis, remained very largely uninhabited during the 3 decades of Armenian occupation, with the exception of a few ethnic Armenians hailing from third countries. Mr. President, members of the Court, as you see from the map on the screen before you, Azerbaijanis and Armenians were clearly treated differently by Armenia. The environmental harm caused, such as the construction of the hydroelectric power plants, deforestation, and the abandonment of agricultural land, was disproportionately perpetrated in areas predominantly populated by Azerbaijanis during the occupation. These zones are shown in yellow on the map. The zones outlined in violet, by contrast, were areas inhabited by ethnic Armenians. It is therefore not surprising that there were no acts of environmental destruction in those areas. The two districts with a major Armenian population prior to occupation, in other words, Khojali and Khojavand, had tens of thousands of hectares of forest and trees in 1994. Over the course of the occupation, each of these districts suffered a forestry loss of less than 1%, whereas the Azerbaijani districts of Fuzuli, Agdam, and Jabrail lost between 31 and 50% of their forests forever. Armenia's attempt to argue that the acts of environmental destruction were spread uniformly in the occupied territories is not founded on any probative basis, and indeed denies the damning evidence presented by Azerbaijan. I would refer you, for example, to the United Nations Environment Programme report appended to Azerbaijan's memorial that documents the difference in treatment of the Azerbaijani and Armenian populations during the illegal occupation by Armenia, as well as the deliberate deprivation of the Azerbaijanis of essential resources to the advantage of the Armenians. Mr. President, at this stage, all this evidence is more than sufficient to prove that the acts of environmental destruction committed by Armenia are capable of falling within the scope of the CERD. This conclusion leads me to address the so-called features of this dispute described by Armenia. Armenia claims that the ethnic Azerbaijanis were not present in the Azerbaijani territories where acts of racial discrimination were committed. This argument, I would say, is moot. It rather misses the point, to use language of the court. As Azerbaijan demonstrated in its memorial, the acts of environmental destruction and degradation committed by Armenia are part of its larger claim that Armenia has conducted a campaign of ethnic cleansing against ethnic Azerbaijanis. And one of the key aspects of that campaign has been to completely change the attributes of the Azerbaijani territories that Armenia has also illegally occupied. The Azerbaijani territories concerned are the 7 districts surrounding the Karabakh region, which I referred to. These 7 districts were historically populated by ethnic Azerbaijanis, not Armenians. That means that, having brutally expelled the Azerbaijanis from their homes, Armenia continued its campaign of ethnic cleansing, in particular by degrading the natural environment in the Azerbaijani territories to the point that it became unsustainable and unhealthy, making life impossible for ethnic Azerbaijanis upon their return. It is therefore of little importance whether ethnic Azerbaijanis were present in the territories when Armenia destroyed and degraded the environment there, given that Armenia's brutal ethnic cleansing campaign aimed to ensure that the ethnic Azerbaijanis would, upon their return, be deprived of their right to enjoy their homeland, including the environment and natural resources that are part of it. It is in this context of displacement of ethnic Azerbaijanis and the placing of obstacles in the way of their return, that Armenia committed racially based discriminatory environmental harm. Similarly, another alleged feature described by Armenia is that the ethnic Azerbaijanis were excluded from these territories by Armenia by military force. Once again, Armenia is not addressing the problem. The expulsion of ethnic Azerbaijanis from their houses and their territories by military force was only the first stage in Armenia's ethnic cleansing campaign. The campaign continued throughout its occupation of Azerbaijani territories. Now, as the agent explained, returning the 7 Azerbaijani districts around the Karabakh region was part of the negotiations between Armenia and Azerbaijan. And what did Armenia do? It ensured that the negotiations failed. Armenia maintained its illegal control over the Azerbaijani territories, and Armenia continued to commit acts of environmental destruction and degradation, with the result that when the time would come for the ethnic Azerbaijanis to return, they would have no homes to return to. Armenia has always known that these districts were populated by Azerbaijanis who had the right to return to their homes and enjoy their fundamental rights pursuant to the third and international law. Armenia treated these Azerbaijani districts and their resources as assets ready to be looted, destroyed, and polluted. This included the forests, the natural monuments, trees, the hydraulic infrastructure, farmed land and vineyards, all essential to the life and livelihood of the Azerbaijanis. The difference in treatment is manifest when one compares the natural environment of the 7 Azerbaijani districts surrounding the Karabakh region with the natural environment of the Karabakh region itself. Yesterday, Armenia also claimed that, and I quote, Azerbaijan does not suggest that the harms it complains of were based on any of the protected grounds, in the sense that that was their stated purpose, end of quotation. We would make 2 points in response. Firstly, in order to determine whether the unlawful environmental behavior of Armenia may constitute racial discrimination, it is of little importance whether the purpose of the wrongful acts has been declared or not. As the court has clarified, the purpose may be inferred. Indeed, in its recent judgment in Ukraine versus Russia, the court examined Ukraine's allegation that the, and I quote, Crimean Tatars and ethnic Ukrainians were subjected to acts of physical violence based on their ethnic origin, end of quotation, and did so on the basis of, I quote, inferences of fact and circumstantial evidence, end of quotation. Secondly, on a related point, the court also stated in the same judgment that, and I quote, a state that is not in a position to provide direct proof of certain facts should be allowed a more liberal course to inferences of fact and circumstantial evidence, end of quotation. This too applies to Azerbaijan. At the point in time that Azerbaijan filed its memorial, it did not have full access to the occupied territories. It therefore was obliged to rely on inferences to ascertain the purpose covered by the third. It follows that Azerbaijan is right to maintain that the discriminatory acts of environmental destruction and degradation committed by Armenia were based on ethnic or national origin. Given that Armenia's wrongful acts were deliberately concentrated on those areas which were predominantly populated and inhabited by ethnic Azerbaijanis prior to being occupied by Armenia. In arguing that Azerbaijan has failed to provide any evidence justifying the objective of Armenia's wrongful conduct, it simply ignores the facts and evidence furnished by Azerbaijan in its memorial. The unlawful campaign of ethnic cleansing and racial segregation conducted by Armenia over decades is well documented. The destruction of hydraulic infrastructure, ground and water pollution, and the restriction of access to fertile agricultural land, to give just a few examples of such practices, have had a disproportionate impact on the Azerbaijanis' right to health, including right to access their homelands. As Azerbaijan has explained in its memorial, the natural environment of the liberated territories is indissociable from the cultural, social, and economic life of the Azerbaijanis. For example, hectares of mulberry trees were destroyed by Armenia. Historically, these trees have been important to the Azerbaijanis as they are used in farming silkworms, a traditional means of subsistence for them. Nonetheless, or rather, similarly, the national monument trees, which are of cultural importance for the Azerbaijanis, were destroyed during the Armenian occupation. All the destroyed trees were located in those districts which were predominantly populated by the Azerbaijanis prior to the occupation. Before the Armenian occupation, Azerbaijan had created two nature reserves and 4 nature sanctuaries in the Karabakh region with a view to protecting and conserving historically important environmental areas. However, Armenia has not protected these areas, which are environmentally and culturally sensitive. For example, owing to the discriminatory acts of environmental destruction committed by Armenia, the Drabrayil and Kubadli districts suffered severe forestry damage. The experts point out that more than 2/3 of the quantified harm, 745 hectares, occurred within Gubadli State Gubadli State Nature Sanctuary, a place of special importance for protection of natural resources. Rare eastern plain trees were felled in the Basi-Che National Nature Reserve in Sangilan. What is more, Armenia deliberately diverted and mismanaged the water of the Sarsang Reservoir in order to deprive the Azerbaijanis living in the areas adjacent to the occupied territories of access to the water they needed for human consumption, sanitation, and crop irrigation. The Council of Europe's Parliamentary Assembly adopted Resolution 2085 in 2016 in response to this conduct, calling upon, and I quote, the Armenian authorities to cease using water resources as tools of political influence or an instrument of pressure benefiting only one of the parties to the conflict. End of quotation. Inter alia, the resolution states that, and I quote, the deliberate creation of an artificial environmental crisis must be regarded as environmental aggression and seen as a hostile act by one state towards another, aimed at creating environmental disaster areas and making life impossible for the population concerned, for the citizens of Azerbaijan living in the lower Karabakh Valley. End of quotation. The wording of the resolution leaves no room for doubt. The conduct of Armenia, which was objected to by the Council of Europe, targeted Azerbaijanis by denying them the ability to enjoy and exercise their fundamental rights. I might add that Armenia's assertion that the reservoir was damaged and never repaired does not help in any way. Rather, this statement shows that, although it controlled the reservoir, Armenia never took the measures necessary to repair it, and so deprived the Azerbaijanis of access to water until 2022.
Mr. President, let me now come to my second point. The claims made by Azerbaijan underline a harsh reality, that of a difference of treatment, which had not only the purpose but also the effect of infringing the fundamental rights of Azerbaijanis, in particular, their right to health and their right to property. Armenia is seeking to discredit these allegations by claiming that the rights to health and to property are outside the scope of the CERD. However, these rights, like other fundamental rights, do in reality fall within the scope of the CERD. Furthermore, Azerbaijan's allegations, according to which Armenia treated Azerbaijanis differently on the basis of their ethnic or national origin, the purpose and the effect of which was to infringe the recognition, the enjoyment or the exercise of their fundamental rights, are not limited to the right to health and the right to property. They also involve other related rights, such as the right to water and the right to return. I hardly need to recall that the destruction of the environment, be it intentional or not, has considerable repercussions on the health and the well-being of individuals and their fundamental rights. According to the terms of the CERD, which are crystal clear, the court has jurisdiction to assess the discriminatory behavior of Armenia when it comes to the destruction of the environment, which affects the right to health of Azerbaijanis. Article 5 of the CERD explicitly refers to economic and social rights, including the right to health, recognized in Article 5(e)(4) as a fundamental right which must be protected with no distinction based on race, color, or national or ethnic origin. This right must be interpreted as meaning the highest attainable standard of physical and mental health, embracing a wide range of socio-economic factors that promote conditions in which people can lead a healthy life, including food, nutrition and sanitation, housing and work conditions, and a healthy environment. Armenia is mistaken when it claims that this right is only infringed when the protected group suffers adverse effects on its health or when it is faced with potential risks for health in the region where it physically resides. Armenia also wrongly claims that actions destroying the environment also took place in areas where Azerbaijanis were not residing. Mr. President, Armenia is seeking to impose its own restrictive interpretation of Article 5 of the CERD. Now, nothing in the CERD can justify this restriction, especially if we bear in mind that Armenia has deliberately carried out actions in Azerbaijani areas in order to create an unhealthy environment, preventing Azerbaijanis from returning home. Armenia has wrongly claimed that the decision of the CERD committee invoked by Azerbaijan only applied to indigenous populations continuing to use and occupy their land. This is a truncated interpretation of the decision, as the committee actually noted that the activities carried out by the United States hindered access to and use of these areas. Another aspect should also be borne in mind. The denial of the right for an individual to return home, as enshrined by Article 5 of the CERD and other human rights instruments, amounts to a fundamental breach of human rights. This denial is all the more blatant when the situation of the occupied state makes the housing unsustainable and unhealthy. Furthermore, the links between environmental conditions and public health are broadly recognized in international law. For example, the Committee on Economic, Social and Cultural Rights, in its General Observation number 14, has recalled that the right to health includes access to a healthy environment as a determining factor of health. When the action of an occupying state results in environmental damage, making a home unfit for habitation, This is a breach not only of the right to return, but also of the right to health. This multifaceted breach illustrates the interconnection of human rights and the need for an integrated legal framework in order to meet the complex challenges which persons affected by armed conflict and occupation regimes are faced with. Armenia also wrongly interprets the right to property, which also comes within the scope of the CERD. It claims that the discriminatory action of destruction of the environment is capable of impairing the right to property only in cases involving, I quote, indigenous peoples residing on their traditional lands. In the framework of the CERD, the right to property is protected by Article 5d5. Its exercise is impaired by behavior degrading or threatening the integrity of the natural environment on grounds of discrimination, of racial discrimination, and CERD imposes no such limits as claimed by Armenia. It creates no special category for indigenous populations as a protected group. The scope of Article 1, Paragraph 1 of the CERD is broad and includes any discrimination based on race, colour, descent, or national or ethnic origin. Furthermore, the CERD Committee has specifically recognised, I quote, that the right to property and to the use, conservation and protection of lands traditionally occupied by them, and to natural resources in cases where their ways of life and culture are linked to their utilisation of lands and resources. As Azerbaijan has underlined in its memorial, the Azerbaijani territories in question had particular significance for ethnic Azerbaijanis with vital cultural relevance. The discriminatory behaviour of Armenia prevented Azerbaijanis from exercising their right of access, utilisation and enjoyment of their property, their lands and their resources. Azerbaijan's allegations, according to which Armenia has destroyed and degraded the natural environment, are capable of falling within the court's jurisdiction in connection with the CERD. Members of the court, the facts and legal arguments submitted by Azerbaijan have adequately demonstrated that the destruction of the environment was based on ethnic or national origin and infringed the equality of exercise and enjoyment of the fundamental rights of Azerbaijanis. This preliminary objection must be rejected. Mr. President, members of the court, I thank you for your attention. My pleading brings an end to the first round of the oral submissions of Azerbaijan. I thank you.
I thank Ms. Boison de Chaussurne, whose oral statement concludes this hearing. The oral proceedings in the case will resume tomorrow, Wednesday, the 24th of April at 4:30 in the afternoon, when Armenia will present its second round of oral argument. At the end of that sitting, Armenia will present its final submissions. Azerbaijan will present its second round of oral argument at a sitting on Friday, the 26th of April at 10 a.m., at the end of which it will also present its final submissions. Each party will have a maximum of 1.5 hours to present its arguments for the second round. I would like to recall that in accordance with Article 60, Paragraph 1 of the Rules of the Court, the oral statements of the second round are to be as succinct as possible. The purpose of the second round is to enable each of the parties to reply to the arguments put forward orally by the opposing party. The second round must therefore not be a repetition of the statements already set forth by the parties, which moreover are not obliged to use all the time allotted to them. The sitting is adjourned.